Hello, sir. How are you?
So, Mr. McCoy, let's talk about something funny.
Okay.
Actually, it's not very funny, but it's actually quite sad. Your lawyer came to me, was it yesterday or was it the day before, asking for a PR bond?
Monday.
Asking me to give you a PR bond. Do you think that was a good idea? To give you a PR bond?
Are we looking at the history?
I
Okay.
You've never, ever once appeared on your own here when we give you a PR bond. Every case that we have with you sits at around 10,004, 10,005, because you never appear. When you come to court, good things happen. Do you understand? If you ever need help, if you need a place to sleep, if you need food to eat, if you need a cell phone or tablet, anything you need, all you have to do is come and ask, and we will bend over backwards to help you in any way that we can. But when you continually fail to appear, you become a flight risk, and we just can't trust you. So he came to me asking for this PR bond. I laughed because I know if I give you one, like little wings on a bird, bye, you just don't come. Next time, if you pick up a case, come and we'll help you with whatever you need. I don't care what it is. Anything you want, I'll give you. You want treatment, you want help, anything. You now stand charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 30 days in jail with credit for the 12 days that you've done. You're giving up a lot of rights by entering into this agreement, Ms. McCoy. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. You know, you've spent the better part of the last 4 years in and out of custody for one thing or the other. Before you know it, 20 years will have passed and you will end up in such a bad place. You're going to look like the things on the street that you'd never think that you would be if you continue at the rate that you are. You need a change before you really do some damage that you can't crawl out of. How do you plead to the criminal trespass? Guilty or not guilty? It's all right. You know what we're doing, right?
Do you want me to talk to her for a moment? I don't.
No.
Okay.
I mean, your plea, do you know what we're doing? We're doing a plea for guilty, right?
Mm.
Is this what you want to do?
Yes, sir.
All right. All right, ma'am, I'm going to find you guilty. I'm going to follow the agreement. Come back next time. All right, good luck. Thanks. Was it 13 days credit?
12.
12.
I didn't. Mr. Proctor,
Okay.
he's not here.
Okay.
He's a bond. He has a surety bond. I called his bond company. I called his dad. I called him. Can we roll it till tomorrow?
Sure.
Okay.
It's FBF tomorrow.
Okay, thank you.
No show tomorrow.
I got you. Thanks.
Oh.
I'm Miss Lovey.
Okay.
So I wanted to address the BDR.
Where is Miss Levy?
It's right there.
Come up, ma'am. So here's Shreya, here's what we're going to do. I'm going to send her for a drug and alcohol test now.
We already did. She came back negative, Judge.
Oh, great. Good job. But if you miss again, it's not going to go well.
So
It is your responsibility to let Shreya know if you're going out of town, if you have some other obligation, because we can always work something out. But I'm not going to continue to do this. If you miss again, it's just not going to go well for you.
So Judge, that's what we want to talk about. So when I was first appointed to her, Ms. Lovey talked to me about her work schedule. And I said, look, we're let's just wait and see what happens with the UAs. If you get called in for a UA, but you have work, I don't want you to lose your job. I told her that.
Yes.
So
They give you a sufficient amount of time to
that
come.
same day.
Yeah, the 6 hours.
Yes. So she's a behavioral technician at Action Behavior Center.
Yes.
Yeah. She cannot take off work.
They penalize me.
So, and do you want to talk to the judge about that?
Yes. I bought some printouts as well on my work's attendance policy. So we have like a 2 weeks ahead of time type thing. They'll let me off. I had to beg and say it was like a life emergency just to get Thursday. I also have asked before because I remember the original court date was for Tuesday, the 18th, I believe. And 2 weeks ahead of time, that court date, I wasn't scheduled to appear. And I said, since I missed that UA, would it help for me to appear in court that day, even though I'm not required to come, to show that I'm okay with appearing to test? Testing is not something I'm trying to avoid or anything, but if I can put, time and effort into make my appearances, be here, and also keep my job security, is there a way that we can balance those two things? Because I have no problem showing up in testing or anything like that. I also live in Humble, Texas. So traffic times, I get off work anywhere between 4:30 and 5:30 every day. And I did bring some printouts just in case that's needed of our policies and everything.
I'm not going to take off the fact that you're not supposed to use alcohol or drugs.
Right.
Absolutely. But is there a way we can schedule her testing? Even if you want her
And
to,
that defeats the whole purpose of it being random.
I know.
Because that's how we catch people. If you know when the test is going to be, it defeats the purpose of it being random. So why do we do this? Why don't we just work something? If you get called on again, call Shreya, and then Shreya can come to me, and then we can work something out somehow.
Okay, and every single time I will need your work schedule.
Yes, and I have printouts
So
from the
just
missed date as
send me
well.
called on, let Shreya know. Shreya can come to me, and we can try to work something.
Okay.
Okay? Because I don't know, you may not get called again. I don't know. You probably will because you missed now, right? But just if and when they do call you, let Shreya know and we'll try to work something out. Okay? Okay. Good luck. Yes, ma'am.
And then we'll just get a reset on this.
Let's get a reset. And your appearances, no reason for you to come, unless, of course, there's a.
So, and I say that, but your appearance was waived, but then when you have the UA, because you can't go to court, then you're gonna have to show.
Okay. Yeah. Mhm.
Okay. Good luck.
Thank you.
Have a seat.
Good morning, Mr. Rivas. Good morning. Sir, you're charged with interference with the duties of a public servant. You're also charged with possession of marijuana ×2, right?
Yes, that's correct, Judge.
So I guess both of the weed cases are being dismissed in exchange for this.
Yes.
You need to understand, Mr. Rivas, that this case is going to go on your record. It will be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, it's going on your record. It'll be there forever. This is what you want to do.
Yes, sir.
How do you plead to the offense? I'm going to find you guilty. I'll send you to it. I'll run your court costs so you won't owe anything. Good luck to you, sir.
Thanks, Judge. Have a good day. Step over here.
Good, yes, Judge. And he's going to come in and sign the conditions tomorrow. I just wanted to talk to you about it beforehand so I could tell him what they're going to be.
Oh, okay. What's your cost?
It is,
So you're just not going to be here tomorrow?
yes, sir. I'm going
Just do
to be,
PC tomorrow?
I'm going to be in Galveston and yeah, we'll waive
You know
PC.
that you can always Zoom.
I know, but it's always hard to do that.
Okay, not a problem. What's your cost?
255-5734.
On Garcia.
Yes, sir.
Got it.
And it's a .1213 breath test. He hit a police car that was blocking an accident scene as he pulled up. It was, no one was in the car. It was blocking the scene. That's the situation.
You want to read it real quick?
Whoa, plot twist! The system just glitched. Imagine if no one caught that? This guy could have faced penalties for armed robberies he never committed. It's a rare peek behind the curtain. A reminder that justice depends on human vigilance. Big credit to the team for catching it, because no prior DWI means a whole different future for Garcia.
Oh, we're still going to do it tomorrow.
Oh, we're still doing tomorrow.
Tomorrow, yeah, we're just kind of like informal PC.
Thank you.
No, never.
I have to keep these and just, one affidavit, but whenever you're ready.
I can come after this.
Yeah, no problem. Whenever
Okay.
you're ready.
Yeah, I'll be right there. Okay. You ready?
Oh, which one?
Oh, yes.
Yeah, go for it.
All right, got it.
So on March 15th, 2025, an officer was working a crash scene in Pasadena, Harris County, Texas. At approximately 1:15 a.m., the officer heard tires squeal and a vehicle collision a short distance away. The officer observed a vehicle had collided with a fully marked police vehicle with emergency lights activated. The officer observed the defendant to be the driver and sole occupant, and he appeared confused and had glossy eyes. The defendant exited the vehicle, and the officer observed red glossy eyes, slurred speech, uncoordinated and lethargic movement, and the odor of alcohol emitting from the defendant's person. The defendant admitted to drinking 2 beers. SFSTs were conducted, 6 out of 6 on the HDN, 3 out of 8 on the walk and turn, 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to the breath specimen, results 0.134 and 0.123.
Any prior to be honest?
No, Judge. Well, let me, actually, sorry.
There's someone else's criminal history. There's no DWIs on it, but there's someone else, clearly someone else's criminal history attached to his out of California.
So that's incorrect. That's not his criminal history. is what
No,
you're
there's
saying?
no way it can,
Okay.
there's like, I can show it to you. It's about every other crime other than DWI is listed from 2017 all the way to now. He's never lived in California. His name is Cesar Garcia.
Yeah, there's gotta be a quintillion Cesar Garcias. But does it match up with the FBI number? I mean, because they always have an FBI number, you know?
I can show you the history if you want to see it, Judge, so you can see it's literally like he wouldn't be here. There's ag robberies, ag assaults, robberies, all of
I don't know. Do you see any prior DWIs?
No prior DWIs on the California history.
So, I mean, I guess do this, you know, if there's no prior DWIs, I'm not gonna put an interlock on it, right? I'm gonna order him no drugs, no alcohol,
Yes, sir.
randoms, that's it. But look to see if it's him or not.
Right, absolutely. I've seen this happen before.
And of course we have to.
Yeah, so
It happens.
we'll look into it.
So, yeah.
because of his age, it just didn't add up.
Oh, is he young?
He's 26 and his history goes back to 27.
I've seen people here 19 with the laundry. So, yeah, you're good. So just pick a date and then we'll do PC again with him. Just no drugs, no alcohol, and randoms. That's it.
Thank you, Judge.
For sure. Did you need something, counsel? Oh, he's coming. We're waiting for him to come back.
Yes, for the result.
Yeah. Okay. I'm gonna.
Thank you.
So, you were Alan Villasana.
Sir?
Mr. Villasana, you were charged with 2 cases. You were charged with theft. You were also charged with racing on a highway. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The theft or the racing, which
Yeah,
was
start on the theft because
on
it's
theft,
the
yes.
earlier one, yeah.
On January 1st, 2025, officers were dispatched to a shoplifter call at a Target in Harris County, Texas. The complainant, the loss prevention employee, called the officer regarding a theft in progress at the location and observed a Hispanic male wearing a tan hoodie and black shorts making a selection and removed a security tape from a JBL speaker box and placed other products inside the shopping cart. The complainant proceeded to keep the surveillance on the male and observe the defendant proceed to exit past all points of sale without any intent to pay for the items. The officer reviewed the surveillance and observed the complainant make contact with the defendant at the front entrance and attempted to retrieve the stolen items, and the defendant proceeded to leave the Target and enter a black Chevrolet Spark. With the assistance of a license plate reader and TLO, the officer determined the motor vehicle to be driven by the defendant and obtained a Texas driver's license, which the officer believed completely matched the Hispanic male captured on the surveillance footage. The total taken was $499.03.
Okay. On the racing, please.
Yes, Your Honor. On March 15th, 2025, the officers observed a black Toyota Camry and a silver Chrysler sedan traveling at a high rate of speed on the main lanes of the Katy Freeway. Officers attempted to catch up to the motor vehicles traveling 120 miles per hour to keep the motor vehicles in sight, but both motor vehicles were still outgaining speed. The posted speed limit was 65 miles per hour. But both the defendant and the silver Chrysler were racing in competition side by side at points, with both motor vehicles accelerating at a high rate of speed, attempting to outdistance and outgain each other. While the defendant and the Chrysler were racing, they were making evasive lane changes and failing to signal lane change, cutting off multiple motor vehicles to get around traffic, causing victims with their motor vehicles to take evasive actions to avoid collisions. The defendant's motor vehicle at one point drove on the right shoulder to pass vehicles in the right lane and was in front of the silver Chrysler. A traffic stop was
So
initiated.
driving on the shoulder
Yes,
to
on the
get,
shoulder. A traffic stop was initiated and the officer made contact with the defendant, who was the driver. The defendant admitted that he was racing with the other vehicle and that this was not.
Let that sink in. He didn't just admit to racing at 120 miles per hour. He admitted he'd have run if his car hadn't run out of gas. That's not recklessness. That's a total disregard for human life. No wonder Fleischer's response is an immediate driving ban. This isn't a traffic ticket. It's a recipe for disaster.
His first time racing, but his first time arrested, and that he would have ran from the officers if he had more gas in the motor vehicle.
Mr. Villasana, I'm going to find that there's probable cause to go forward on both of your cases. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke the bond on both of your cases and I'm going to put you in jail. I'm also ordering you now not to drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
How long?
While this case is open, and if I find that you do, likewise, it's not going to go well for you. Do you understand?
Yeah.
Can you print me out more affidavits, please? You're not to go to any target whatsoever as well. If I find that you pick up a third case, it's really not going to go well for you. Do you understand? I'm going to do everything in my power to protect my city at all costs. And if that means putting you in jail and making your bonds high, I'll do it in a heartbeat. Do you understand? Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
I didn't have a job right now, so I can't.
Okay. Deputy Miranda's going to give you an application. I'll have you fill it out and I'll take a look at it with you. Hey, I'm not done talking to you. I'll have you take a look at I'll have you fill it out. I'll take a look at it. I'm going to have you sign a receipt with Victoria. I'm going to have you come back because I'm going to have you sign an affidavit with me today promising me you're not going to drive. And then you'll get with Fleischer for your bond conditions.
I won't be able to come back. I don't have a right.
Figure it out. I'll get you a lawyer and we'll start talking. But I don't want any more problems. Do you understand?
No, I haven't been in problems like 5 years. This is the first time I had a case since 5.
Don't. Please. Good morning, Mr. Alipio.
Yes.
Sir, you were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 13th, 2025, an officer observed a blue Ford F-250 driving at a high rate of speed. The officer paced the Ford driving 79 miles per hour in a 60-mile-per-hour zone. The officer observed the vehicle to fail to maintain a single lane, driving over a solid dash line, and driving between two lanes with other motor vehicles in the area when the vehicle failed to maintain the single lane. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed the defendant to have slurred speech. The defendant stated he drank one alcoholic drink prior to the traffic stop. The officer observed the defendant to be staggering while walking, using the motor vehicle for support, and the defendant to have the mild odor of alcohol upon his breath. The defendant appeared confused and the officer had to repeat himself multiple times. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 8 clues observed on the walk and turn. 3 out of 4 clues observed on the one-leg stand. The defendant stated he drank 2 to 3 alcoholic drinks prior to the traffic stop. The defendant was arrested. An inventory search was conducted of the defendant's vehicle, and the officer observed a warm to the touch, white cup in the center console.
Alcohol while driving?
3 to 3/4 full while with the smell of an alcoholic beverage. The defendant was read the DIC and refused the breath test. A blood search warrant was signed and executed.
Mr. Alipio, I would hope that you would recognize it's elementary that you're not to have alcohol in the car while you are driving. I'm going to find that there is sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. I am now also taking away your privilege to drive. You are not allowed to drive. If I find that you do, because I will have you sign an affidavit, a promise with me that you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, likewise, you will go to jail. I do not know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
I am sending notice to DPS that there is now a restriction on you that you are not to drive any vehicle that doesn't have an ignition interlock on it. If you were caught driving a vehicle and it does not have an ignition interlock, every officer in the state will know to arrest you and put you in jail. Do you understand?
Yes.
Your Honor, just to clarify, so he can drive so long as he has a guardian ad
No, I'm taking away, he's not allowed to drive at all.
Would you consider reinstating his ability to drive because owns his own business?
I'm not ready yet. All I know is that he's got alcohol allegedly in the car while he's driving, and it's a second offense. Look at me, Mr. Alipio. Do not drive. Do you understand?
Yes. Yes, sir.
Because of this restriction, you will now be required to obtain a portable device that you're going to take with you everywhere you go to prove to me that you are not consuming alcohol. I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it. Because if I see it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes.
Yes.
Because you have a lawyer, I will waive your appearance. That means that you don't have to waste your time coming to court. But it is your responsibility to stay in touch with Lee. If she tells me that she can't get a hold of you because you're ducking and dodging phone calls, you're playing games, you're not responding to her, likewise, I will issue a warrant for your arrest. I'm going to do everything in my power to protect my street at all costs.
And just like that, the room goes cold. That wasn't a warning. It was a promise. A second DWI plus an open container moves you from a maybe to a definite problem. The stakes aren't fines anymore. They're custody and the loss of privilege. Fleischer's drawing a hard line, and you do not want to cross it.
I have no qualms about putting you in custody. If you don't believe me, ask Lee. She knows. For now, I will have you come up here, swear to us that you're not going to drive. After that, you'll get to Victoria where we will have you sign a reset. After that, you'll get with Felicia for your bond conditions, and after that, you'll be free to go. It's not forever, but I want to know that he truly appreciates and not just, oh, I'm sorry.
Yes, Your Honor, his prior DWI was in 2003, so he had not had alcohol in any long time.
How do we know? How many times has he not been caught that we just don't know?
No.
I don't know, but all I know is he's got alcohol in the car. He has a prior DWI, so he's already on notice of what you can and can't do. I have a problem. So
Yes, Your Honor.
just proactivity goes a long way.
Yes, Your Honor.
All right, good luck to you, Michelle.
You know, here for Mr. Flores, Adrian Flores. He's in the holdover. He's got a terroristic threat on a serious bodily injury charge. Represent me.
Hey, how are you?
Harold, what would you like? What are we doing?
Just today was the day we're going to come back for the mental health evaluation, and they just sent it to me this morning. Haven't had a chance to read all of it. They did say he was competent, but I still don't think something's right with him. I talked to him.
So get a second opinion. You know, if you need money for a second evaluation, I'll give you money.
And I don't know. I mean, it might be he's competent, but just something's not correct, you know, with our thinking and reasoning when I was.
Are you able to communicate with them?
I am. Well, just for instance,
Limited fashion or something, or what?
Sorry?
In a limited fashion?
No, he communicate, just for instance, I was just told, well, I just want to go ahead and work it out because then I'm going to hire an attorney. We're going to get them all dismissed later. I'm like, no,
Yeah, don't worry.
if we're going to do this, we got to do it now. We have to decide if we're going to trial now. And
That's
then-
I want to get out as quick as possible and then
Kind of, but that was a little more than that though. Just,
to talk to him.
I mean, I guess it would be a safe thing. Just explain to him what's going on.
Do you mind bringing out Mr. Flores? Do you need a translator?
No, sir.
Adrian Flores, please.
And I think he understands now, but it just might be a misconception, maybe jailhouse lawyer talk or not understanding his
I don't know.
cases.
Does he have his pending in the 220? This case?
No other cases pending as far as I know.
Good morning, Mr. Flores. How are you?
Good today.
Good. The reason that you are still in custody is that we gave you a PR bond and you take off. You don't come back to court. This has not happened but once. It has happened already multiple times. So that's why I can't just continue to give you PR bonds. When you do, you just take off. The only thing I need you to understand is that, you know, when you plead guilty to something, it sticks with you forever. You cannot try to plead guilty to something, get out and try to change it or do this or do that. This is when you do this, when you accept a plea bargain, it stays.
Judge, Your Honor, I'm truly sorry for what I've done, like my whole life. I just asked for another PR bond. I'll make it to court. I actually call my mom, see if I could stay with her until she drops me off at court, and whatever they say from there, if I'm guilty or not guilty, I'll plead guilty. Or if I'm innocent, I'll
Where you living
innocent.
now?
My mom stays in Tomball now.
No. Are you living on the street or are you living?
I'm homeless, but I've actually talked to my mom, and me and her actually going into a good relationship now,
Did you just get picked up?
like mother and son. And yeah, like they caught me at the airport, and
Look, I don't want you to talk about the case. The thing is that I don't want to continue to give someone a PR bond if you're just going to go to the streets. The streets are not a safe place.
I won't go back to the street. The streets
I know.
aren't for me anymore, man. Like I don't want to be in the street. I don't want to be homeless anymore.
This is the real human dilemma. Is this a true turning point or just courtroom talk? Fleischer faces that question every day. He wants to believe in redemption. You heard him offer help before, but he knows the streets are a powerful pull. What would you do? Give him the chance or wait for proof through a mental health evaluation? This is where the law meets real life.
I've talked to my mom. She's doing real good, and she actually wants me to be around. pay the bills and, and own a house of my own,
Let's do this. Why don't
After,
we do
you
a
know?
TRAS to see how we go forward? Because I don't know, and we can have the clinicians evaluate him to see how we go forward.
First?
If you want to do an independent one, I'm happy to give you money for you to do it. Or like I would suggest is just do a TRAS to see where do we go? Because I don't know, but having clinicians talk to him might be the best way to go to see how we go forward. Because the problem is, Harold, is if we just throw him out to the streets, we're throwing him out to the wolves. If he doesn't have a place to go to, or just, whereas if we have him TRAS, we can try to get down to what the true issue is and why it keeps happening, and then we'll figure out a plan, So you just let me know whatever you want to do. I'm happy to do it.
And so just, we're gonna do the TRAS, we just set that up with the CLO or?
Yeah, so we'll have Shatori set it up and we'll do it. We can expedite it so it gets done within the next couple of days, so he's not just lingering.
Judge, as his competency is also good then?
Yeah, competent. Yeah,
Bird?
so we can get it done. And then that'll really tell us, perhaps it needs to be in mental health court. I don't know. But that's what we can get the TRAS for.
So what do you think, there's 2 weeks or?
No, not even a week. A week. Okay, thanks. All right, Mr. Flores. Good morning, Mr. Lundy. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 12, 2025, at approximately 4:45 p.m., an officer was dispatched to an FSGI call. Upon arrival, the officer spoke to the complainant, who stated he was traveling north on FM when a vehicle crashed into his vehicle. The driver then fled the scene without exchanging information. Complaining witness to the passenger stated that they were rear-ended, causing the defendant's vehicle to crash into a ditch. Defendant then approached them to check on their welfare, and once he saw they were unharmed, the defendant fled the scene on foot. The officer observed significant rear end damage to the complainant's vehicle. The complainant provided a description of the defendant, and the officer ran the license plate and found the registered owners were Michael Lundy and Dylan Lundy. On March 13, 2025, the officer received a call from Dylan Lundy, who wished to provide a voluntary statement regarding the incident. The defendant admitted to crashing into the complainant's vehicle and to fleeing on foot because he believed he had an open warrant for failure to appear for a window tint violation. The complainant positively identified the defendant by photograph. The estimated cost to repair was over $200, as the complainant believed their vehicle was totaled.
Okay. Can you run his license, please? And does he have any open cases anywhere? You can run an NCIC.
His driver's license is eligible, and I normally don't take note of Class C violations, but I do.
No, I don't care about Class C.
Right.
No, I don't care.
He does not have any open
Nope.
cases
Okay.
at the moment.
Got it. All right, Mr. Lundy, I'm going to find there's sufficient probable cause to go forward with the case. The only condition I'm placing on you now is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you may not drive. You understand?
Yes, sir.
Okay, I will waive your appearance because you have a lawyer. Just stay in contact with Will. He'll tell you if and when you have to come back to court. I'll have you sign a receipt, Victoria, while you take a seat while we get your conditions. You'll sign it and then you'll be free to go.
Thank you, Judge.
Don't
Thank
pick up
you,
any
Your
new
Honor.
cases.
Yes, sir.
Is that pre-trial bond condition?
State's conditions.
Okay.
Okay,
Next is
so-
on page 12. Howard, come on up.
Can you file those, please? Good morning, Mr. Phillips.
Good morning, Your Honor.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 12, 2025, at approximately 9:25 a.m., an officer was conducting a stationary traffic enforcement on a public roadway of the 7,000th block of IH 610 southbound in Harris County, Texas. The officer observed a red Ford pickup truck traveling at a high rate of speed with heavy traffic at the posted limit was 60 miles per hour. The officer witnessed the pickup truck bypassing other motor vehicles, weaving in and out of traffic at high speeds and coming dangerously close to other motor vehicles, with other drivers having to brake to avoid collisions as the Ford cut in front of them recklessly. The officer witnessed the pickup make multiple unsafe lane changes. A traffic stop was initiated. The officer reached speeds up to 110 miles per hour to catch up with the truck, but the pickup continued to distance itself from the patrol vehicle. The officer made contact with the defendant, driver, and sole occupant. The defendant admitted, "I know I was driving like an idiot. I just got off work." The defendant acknowledged he was aware that he could have caused an accident and hurt someone.
Mr. Phillips, I'm going to find that there's sufficient probable cause to go forward with the case. If I find that you drive like this again, it's really not going to go well for you. Do you understand?
Yes, sir.
I will protect my street at all costs. If that means putting you in jail with a $500,000 bond, I'm going to do it in a second. Do you understand?
Yes, sir.
Any more, I will also take your privilege to drive away from you as well. Can you look to see if he has a license?
Yes, his driver's license is eligible, Your Honor.
You are not allowed to drive unless you have valid liability insurance in your name, and that is also now a condition of your bond. No reckless driving, maniacally driving, donuts, street takeovers, anything of this nature. Do you understand?
Yes, Your Honor.
You will sign conditions to this, and after that, you'll be free to go. You have a lawyer, I will waive your appearance. Just keep my street safe, man. Every day we have people dying. It's not fair. Do you understand?
Yes, Your Honor.
Okay, come on.
Thank you, Judge.
Right this way.
You are Mr. Al-Bardon? Sir, you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 12, 2025, an officer responded to a weapons disturbance call at a residence in Katy, Harris County, Texas. Upon arrival, the officer met with the witness, who stated the defendant, her brother, and the complainant, her sister, were inside the residence and were involved in a verbal disturbance. The witness believed the defendant walked upstairs to retrieve a firearm during the altercation, which caused her to walk out of the residence and call 911. The witness, the complainant, and the defendant were eating at the dinner table, and the defendant told the complainant that he will shoot the complainant and the complainant will need to leave the residence. The complainant stated that she lives at the residence with the defendant. The complainant stated the defendant got into a verbal altercation with their father, and the defendant stated that he was the man of the house. The defendant attempted to slap the complainant in her face, and the complainant moved her head back, causing her hijab to fall off her head. The defendant told the complainant he would grab a gun, hold her down, and shoot her. The defendant would see that the complainant would not be in the residence. The complainant stated she felt in fear when the defendant threatened to shoot her.
Mr. Al-Bardon, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case that identifies Ms. Lubna as a protected individual. Get to know this protective order, because if you do something to violate it, the state can and will file a violation of a protective order against you. And it's one of the worst cases that you can pick up. Do you understand? One of the things is this comes with a residential restriction that you're not allowed within 200 feet of the Park Fair courthouse. Do you understand? If you go back to this place, it's not going to go well for you. Do you understand? How old are you, sir? How much? 33. Do you work? Do you have the ability to hire a lawyer? So what I'll do is I'll have you fill out an application for me. I need to know whether you can qualify for a court-appointed lawyer. Any allegation of alcohol or McKenzie, any alcohol or any dope, anything like
No
that?
allegations of alcohol.
Okay. So for now, what I'm going to do is I'm also ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand? I'll provide you a lawyer today and we can talk about how we go forward, but just be careful. I don't want to have to put you in jail. Do you understand? Okay. Do you mind giving me an application? Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. Good morning, Ms. Burse.
Sorry, I lost my voice.
Burse, that's what's right?
Yes.
Okay, ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. Just hang tight and we'll, okay?
On March 13, 2025, an officer responded to a criminal mischief call at a residence in Harris County, Texas. The officer made contact with the complainant and the witness, who directed the officer to the scene. The complainant stated the defendant came to the location, broke his motor vehicle window, and recorded the incident on his phone for the officers to see. The complainant stated the defendant left the location in a black Kia that had the location on. The complainant stated the defendant was on Rust Creek Drive at an apartment. He could point to her apartment. The cost of the damage to the motor vehicle was approximately $500. The officer reviewed the video and observed the defendant striking the front passenger window, causing the window to shatter, then leaving the location. The officer observed a brick inside the motor vehicle with glass shards inside the front passenger seat, floorboard, and outside the motor vehicle. The complainant was positively identified by her Texas ID prior to driving to her location per GPS. The officers followed behind, and the complainant pointed at the apartment as the defendant was standing right outside of it. The officer made contact with the defendant, who was wearing the same outfit in the video, and the defendant admitted to breaking the complainant's window.
Got it. Do you have the rip done? I'm assuming this complainant doesn't want to have contact with her?
We have.
Not yet? Okay. Ms. Burse, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, Your Honor.
I don't care what's going on in your life. Don't have any contact with this person. I'm also ordering you not to be in possession of your weapons as well.
Okay.
If I find that you're a danger to my community, it's not going to go well for you. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? Are you sure?
Yes.
Do you want to apply for a court-appointed lawyer?
If I really don't need one, then no.
You need a lawyer.
Okay, then
You're facing 6 months in jail,
then yes.
$2,000 fine, plus it could go on your record, and it's disastrous when it goes on your record.
Yes.
It's a good idea. Do you mind giving her an application? So I'm going to have you fill out the application. I'll have you take a seat in the jury box. So we'll get your bond conditions. Do not leave until you sign them. And then I'll have you talk to a lawyer here momentarily. All right. Good morning, Mr. Miller. Sir, you're charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The complainant informed the officer that on November 9th, 2022, in Harris County, Texas, the defendant was sending the complainant harassing text messages to the complainant. The complainant and the defendant had been in an on and off relationship and had recently ended it. The defendant would call and text apologies that he would love her. The complainant stated eventually that the defendant started conveying messages that were angry in context. The complainant blocked him in response, and then she began receiving calls and texts from unknown numbers. The complainant even asked the defendant's mother to tell him to stop calling her. The complainant stated that the night that she received calls and that night she received calls and texts from the defendant with him threatening to call Child Protective Services. The complainant and the defendant were using an app and calling and text. The defendant was using an app and calling and texting from different phone numbers, and he sent multiple phone numbers and different text messages that are outlined in the officer's report.
Gary Phillips.
Are we talking like tons of text and stuff? How many are we
Yes,
talking?
Tons of texts from different phone numbers after the complainant had repeatedly told him to stop.
Okay, I see. I'm looking at dozens and dozens. Okay. All right, Mr. Miller, I'm going to find there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. I don't care what medium it is. I don't care if it's a smoke signal. I don't care if it's with Snapchat, WhatsApp, social media. If I find that you do, I will revoke your bond and put you in jail. Do you understand? No means no. Just, you don't have children with this person. Move on. 10,000 other fish in the sea. It's not worth it sitting in a 6x9 because of one person, right? All right. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you have the ability to hire a lawyer?
Yes.
Okay. So what we'll do is we'll give you time to hire a lawyer. I'll have you sign a reset Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Please. Good morning, Mr. Runyon. Sir, you're charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 23rd, 2025, A witness stated that he saw the defendant dump a sofa on the 22-800 block of Fair Lake Lane on Tuesday, January 21st. The witness stated that he was cooking and looked out of his kitchen and saw a truck and the defendant come out to dump it. And the witness took a photo of the defendant's license plate and of the defendant. The witness told the defendant that you can't dump trash there, and the defendant looked up at the sofa he already dumped and left. The witness stated he was concerned the defendant was going to dump the sofa at a nearby location. So the witness drove to the main roadway near his house and observed the sofa had been dumped at an abandoned car wash located at 11440 FM 1960 in Huffman, Texas, which is not an approved dump site by the Texas Commission on Environmental Quality. The witness is positive that the sofa is the same brown sofa that the defendant dumped near his house previously.
But he didn't see it.
No, Your Honor, but he did it was the same sofa, and he did follow, and then at that point, the sofa was still on the side of the road.
Yeah. The witness stated he was cooking, looked out his kitchen.
I know that he sees it. So he doesn't dump it that first time. He goes to a location, he's about to dump it, but he doesn't, he takes off.
So
Right?
I would just request, this is not with us, this is with environmental. I would just request we hold off on PC ratings until the prosecutor hears it's based on.
Okay, I mean, I'm willing to hold it, but you know,
I get it. I just want to make sure the prosecutor.
Mr. Runyon, just take a seat for me in the jury box, please.
Morning, Judge. I have a gentleman by the name of Kayuba Thomas who is with us today. He has a warrant. It's kind of questionable, but nonetheless, he does, and he wanted to turn himself in.
Okay.
I wanted to see if depending on probable cause, if you did set a bond, whether you might consider a PR bond because his medical condition.
Don't worry about it.
Gotcha. Would you like him brought up, Judge?
Please.
Okay. Mr. Thomas?
Good morning, sir. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
On February 6, 2025, the officers interviewed the complainant, who stated that on January 18th, 2025, the defendant came into the 5-minute oil change located at 747 Gary Ashford Road in Harris County, Texas, to have maintenance performed on his vehicle. The defendant let the complainant perform a cabin check on his vehicle, so the complainant got inside the vehicle. The complainant and the defendant then exchanged a verbal exchange because the defendant was upset that the complainant was inside the vehicle. The complainant's manager interviewed and attempted to de-escalate the situation, and the defendant told the complainant's manager, "I'm going to come back here, you better correct him before I come back here. I'm going to come back here and I'm going to finish him off with a gun. I will fucking come shoot you all. I will do a drive-by." The complainant confronted the defendant and told him that he was not welcome back. The next day, the defendant was captured on surveillance footage at the location speaking with the complainant's coworker, who informed the defendant that the complainant was not at the location. The defendant went into his armrest and the witness stated that the defendant went into his armrest and he pulled out his gun while uttering the words, "Because of what happened yesterday, I should have shot his ass," referring to the complainant. The defendant stated, "I'm going to come every day until I see him."
And Judge, that's simply not true. In fact, I have his.
Remember, this is a probable cause.
I
We
understand.
start getting into more stuff. I mean, my only concern is, was there a terroristic threat, right?
Exactly,
And I don't know, it looks like there were potential multiple threats. So which one is in the charging instrument? Is
I think the one alleged to have occurred on
on the actual day in question when everything,
I can look and
Yeah.
double check.
because what I have, Judge, is just a receipt from when he paid. And because of the way he was treated, they gave him a $20 discount. It shows on the receipt as well. So, you know, he had told them, "Don't upsell me, don't upsell me." He comes around the corner and the guy's in his car. So that's why they gave him the discount on the receipt.
but I mean,
Even so,
Did-
Your Honor, a discount what happened.
No, I understand.
And just to clarify, it is the first threat on
first
January
threat.
18th.
Yeah, I mean, it's,
It is what it is. I understand.
so Mr. Thomas, I'm going to find that there's sufficient probable cause to go forward with the case. The only thing I'm going to ask you to do is don't have contact with the complaining witness. don't be in possession of weapons, and don't go back to the 5 minute,
5 minute oil change.
Yes,
the
sir.
5 minute oil change. That's all I'm asking you to do, really. Just don't have weapons and don't go back, okay? That's it. As long as you can.
Also ask for no contact with the complainant.
Of course.
We'll fix it. Alrighty. Anything further, Judge?
Hold on, we have to do bond.
Oh, I'm sorry.
Am I putting me out of PSR? Sorry.
It's already set at $100.
Oh, it is? Okay, so I don't need to. All right. So, Mr. Thomas, I'm going to grant you a PR bond today. You have a bond set at $100. I'm going to grant you a PR bond. All I'm asking you to do is just don't pick up any new cases. Just be nice. It's not hard. You've got a great lawyer here. Listen to him. He'll take care of you. I'll waive your appearance because you have a lawyer. You don't even have to come back. Just stay out of trouble and just, that's it.
Okay, thank you very much, Judge.
So I don't let him, I need you to sign a bunch of paperwork. We have bond conditions that we're going to create. I need you to sign them. Do not leave until you sign our bond conditions. You'll have to meet with police for your PR bond. And after that, you'll be free to go. Okay? All right.
All right, thank you very much, Judge.
And then, Judge Powell, do you?
Yes, sir.
Attorney record, please?
Yes, sir, certainly.
We have them over there in the tower.
Okay, thank you.
Judge, I need the.
Sir, you were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in a car, an officer comes up to your window, they see that you have a prior DWI and they smell alcohol on you, or they smell anything funky, it's probably not going to go well for you. What we're doing today, the proverbial slap on the wrist, will not happen again. From now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You're giving up the right for trial. Held witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this. Do you understand?
Yes, sir.
You still want to do this?
Yes.
Is it true or untrue that you had a
no es verdad
5 or
que
above?
tenía un 2 o 5 más? ¿Verdad o no verdad? ¿Verdad o no verdad?
Sí. ¿Verdad o no verdad?
True.
Answer. All right, sir, I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I am going to suspend your license for 90 days.
Yes.
Do not drive until you get a license. And I'm going to tell you now, I will waive the $4,500 surcharge that normally applies in this type of case because we all make mistakes. But if you continue to make mistakes where you endanger other people's lives, a second DWI, not only is a minimum of 90 days, but it's a $6,000 surcharge. Do you understand?
Yes, sir.
All right, good luck.
Thank you, Judge. Have excuse.
Thank you.
Hey, you ready? Come on.
Yeah, I just want to approach on bond conditions for Mr. Barden.
Okay.
B-A-R-D-S-O-N.
So you got appointed Mr. Albardan?
Yeah.
Great. Okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive contact.
And I'm okay. So he's Mr. Albardan. Come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them, it's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is. And it can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, Be very careful, because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right, I'm done.
Thank you, Judge. I'm excused.
Thank you. The only, so, Mr. Albardon, the only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, no.
Okay. All right.
I will convey that.
And if you can file, no, now we need,
State bond condition.
yeah. So, Mr. Reedy, we need new bond conditions. He can't leave just yet, so we need him to sign no
Okay, I
threatening
told
or
him to
harass.
put right there not to leave.
Okay.
Yeah.
Stay.
Last name is Bledsoe.
Bledsoe?
Bledsoe.
Okay. You want to bring him on? Are we going on the evading and the terroristic threat? It's going to be dismissed. Good morning, Mr. Bledsoe. You were charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're going to dismiss your terroristic threat in exchange for your plea on the evading arrest. You need to understand that the evading is an enhanceable offense. This is going on your record today. It'll be there forever. From now on, if you ever run from the cops again, you'll be facing a felony charge, years instead of days. Do you understand?
Yes, sir.
Not only that, it's a minimum now of 90 days for any new cases that you pick up in here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays on your record forever. Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense, sir? Guilty or not guilty?
Good, sir.
I'm going to find you guilty. I'll sentence you to the agreement. If it's enhanced, it'll be abandoned. Good luck, sir.
Thank you, Judge.
Anna, we have court orders for a reason. And when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are, you know,
Sorry. I mean,
it's okay. No, and I think you're right. You know, we were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to, I want to stick with the agreement that the county came to with the district attorney's office,
so, I'm not saying do this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
And here's my question then for the board, and I'm not saying we do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, does that say we can't take it to grand jury?
You can, of course you can.
So.
Just because I find no probable cause on something, if you want to go indict it, go do it.
Right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them. As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
Yeah, I'm just, and this is for my own.
And you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you, Judge.
Oh, really?
I just, so we wouldn't be held to that same standard at grand jury.
You need to do what you think is right.
Okay.
Like I'm going to do it, and like
Absolutely.
she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is Which is good.
Thank you.
God love you.
Good morning.
Is it? All conditions will continue. You are not to use. Do you understand?
Yes, sir.
I will test you again in about 45 days. If you test positive again, it's not going to go well for you. I'm not asking much. Do you understand?
Yes, sir.
Okay. All right.
And
That's
we are
it.
doing, we're working on a PTI with the,
Quicker you get it done,
that's what I'm saying, with,
quicker it is for
they
you.
do want to test as well as a condition, so, once we test them again, then we get submitted.
You hold the keys to the jail cell. No one else. Do you understand?
Yes, Your Honor.
Thank you, Your Honor.
Yes, ma'am.
Thank you.
Yes, Your Honor.
I'm going to find that there's no probable cause to go forward in your case. Aren't our streets dirty enough?
Yes.
Don't say anything. Just please,
Understand.
keep it nice.
Yes, sir.
All right, please.
Thank you.
Carter.
Hey, Judge, may I approach?
So you got something interesting?
Oh, we were going over, on this case, we were talking about, if a private citizen, takes somebody's car key and seizes somebody and holds them there till the officers show up, is it, allowable or not? And so,
Well, it would have to be a felony or a breach of the peace, right?
right, it would have to be one of those, because otherwise it could, I was telling them it could be argued it's fruit of the poisonous tree, it's an unlawful seizure. And so if it's a government action, it's.
I thought you were getting more toward a like kidnapping.
Oh, no, to like say it's an unlawful seizure, like, there's, we were comparing versus, it's not because it's a private actor. But I'm saying, hey, even if it is a private actor, if it effectuates what a cop would be doing, it would fall under the same tenets of unlawful search and seizure. And so,
Certainly interesting.
yeah. I don't think we're going to get there, though. I don't think we're going to get there on this one. I don't think we're going to get there on this one. It's
Theory's wonderful,
Makes you start fun. So,
Yeah.
Mr. Lázaro Echemedia.
It's old.
Yeah.
What do you want to do?
So we're set to plea or set it for trial today.
Correct.
I see some issues in the case. I've talked to my client. He is interested in possibly doing something different, but he is,
I mean, what other
we
different?
need an immigration consult, well, possibly time served. But the thing is, the holdup is, I need an immigration consult.
That should have been done beforehand. I mean, today we're set plea or trial. This is not.
Right, and the only thing is,
We're now 215 days.
the thing is, I was only appointed like a month ago. I saw all these issues over the weekend. And so talking to him, see if he wanted to go to trial, he's like, hey, hold on, let's get an immigration consult, see how it's going to affect me. So
Okay, so I guess I'll give him till Monday.
the only thing with that is, Judge, this consult goes through the MAC. It's Miss Julie Pash. Today is Thursday. She's been getting on me about how backed up she is lately.
It's 215 days old, dude. I mean, it should have happened a long time ago.
Right.
You can't just, it's on him. It's not on you. It's on him.
Yeah, I'll be straight with you, Judge. I don't know why I was only appointed like a month ago. I don't know if he was missing or something.
Correct.
was
He's been AWOL from that. So
So,
it's not, I mean, I'll give you a week, but that's it.
okay, I'll let her know. I'll let her know and hopefully she gets it done. Thank you, Judge. All right. Okay, cool. Thank you.